Ask an attorney about Florida law. Ask an attorney, just give him a call.
This is Ask an Attorney, all about Florida law with Attorney Joe Pippen. If you have a legal question, call Joe right now. In Tampa, call 813-287-5700. Anywhere else, toll free at 877-943-9673. That's 877-943-9673. The law office is open. And now your host, Joe Pippen.
Hey, good morning. Welcome to Ask an Attorney, all about Florida law. I'm Attorney Joe Pippen, practicing attorney. The law office is open. Hey, if you have a legal question, all you have to do is to dial a toll-free number, 877-943-9673. The law office is open if you have a question about wills, trust, probate, guardianship, power of attorneys, healthcare surrogates, living wills, family law. Can be personal injury, can be just about any area of law you have a question on. I'll be more than glad to try to help you. I've been host of Ask an Attorney, all about Florida law for over 34 years, and glad to be here and glad to be of some service and try to help you if I can. If you've been worried about something during the night, some legal issue, some problem, it doesn't even have to be a legal issue. It can just be a problem you're in or in the middle of and you don't know what to do. Want a little advice, a little somebody to talk to that can maybe point you in the right direction? Hey, I'm here, 877-943-9673, 877-943-9673. Law office is open. So if you have a question about estate planning, you know, I get to do lots of speaking engagements, and I'm really glad I get to do that. I was at Indian Rocks Baptist Church this past Wednesday night. And basically what I do when I go into a group that needs a speaker, I have a little opening remarks and everything, and then we talk about, I really like to answer questions, just like the show, Ask an Attorney. So audience of, it was probably about 40 people there, and so lots and lots of questions. Questions like, is my out-of-state, I get the question that's probably been my most often asked question during all the years of radio, is my out-of-state will good in Florida? I've now become a Florida resident. Is my out-of-state will good? Well, the answer to that question is a document really needs to be reviewed. It might work in Florida. It's probably going to be better to have a codicil or a new will that says you're a resident of Florida and have it properly witnessed and notarized. I was dealing with a document this week that was signed and notarized. This was a trust document. It was signed and notarized, but not witnessed. And the person was trying to actually do the document themselves, and then they were doing an amendment under the same way, and it just was the first document wasn't valid. And there's no way they were going to try to copy parts of that and do a valid document themselves. If you have a question about anything like that, I'll be more than glad to help you. Let's go to Elizabeth calling from Orlando. Hey, Elizabeth.
Good morning.
How are you?
How are you?
Good. What station are you listening to in Orlando?
I was listening to you online.
Oh, online. Okay, very good. What can we do for you?
My question is, my husband is on Medicare, and I was wondering if I need to do anything to protect my assets, which do not have liens on them.
Okay, are you telling me Medicare is what you said, or Medicaid?
Medicare.
Okay, well, Medicare is not driven by assets. Now, Medicaid is, whether you qualify for Medicaid, like in a nursing home of that would qualify, and you have to be careful about that when you apply anyway. But just Medicare, you have no asset protection concerns about Medicare. Is it possible you go in a nursing home and be on Medicaid?
Well, you never know. But,
yeah. Then you would need some planning to orchestrate the assets so that he would qualify for that, which is a way to do that, of course.
What about Social Security disability? Because he's on that too.
Yeah, now that might be more of an issue to where assets come into play.
Okay.
So what you need to do is to sit down with an estate planning elder law attorney to that you can give a list of assets to and income and his income, your assets, and figure out a plan so that you can maximize your government benefits would be the best thing for you to do.
Okay, that'd be great.
Yeah, and we have an office. I don't know whereabouts in Orlando you are, but we have an office right off of I-4 in Davenport, which is exit 55 on I-4. I don't know how close that is, but if we don't charge anything for a first appointment.
I'm closer to Altamont Springs.
Okay. We have an office in Clermont as well, so we have to figure out. All right. Thank you.
Thanks.
Let's go to Mike in Tampa. Hey, Mike.
Hey, Joe. How are you? Good morning, sir.
Good morning.
Hey, good to talk to you again. Hey, I have a question on real estate, Joe.
Okay.
I have my property line and the church property line. I guess they meet together in the middle of my driveway. And they put a fence up, and I was told to contact the real estate lawyer to see if that's legal for them to do.
All right, the property line is in the middle of your driveway?
Right.
And did you buy the home new, or did you buy a used home?
It's a used home. It was built back in, I believe, 1950 or 54. I bought it from the previous owners.
And how long have you lived there?
2 years.
And
the previous owner, the great grandfather put. I know the history of the home. The previous owner was a good friend with his kids, and the son sort of got sick and tired, so he wanted to move. And the driveway had been used since since the great grandfather put it here. His great grandfather used to work for a muffler place, which the owner he bought it from the owners.
All right, is somebody causing you a problem about this now?
Yes.
So a next door neighbor is causing you a problem?
Right, because they wanted to sell their building, and they said they wanted to get as much money for it as possible. So they wanted me to give them a driveway. I said, no, I don't want to give them a driveway. And since the property line came in the middle of it, they said, well, they'll just put a fence up and block off the driveway.
Yeah, well, if they tried to do that, you would need, you would need an attorney. So there's this thing called adverse possession, and I think you might not qualify because it's you have to be there on more than 2 years to try to make that work.
Okay.
You might have an action against the. Did you know about this when you bought the property?
Know about what there?
That you didn't own all of the property the driveway's on.
Yes. The previous owner informed me that the property line would be in the middle of the driveway. However, about 2 years ago when I first bought the property, I did approach the church about buying a strip that would cover the driveway. And they never got back with me, and all of a sudden now they want to sell it and maximize their profit.
Have you gotten any formal notice, anything in writing that what they're going to do?
No, they just told me they didn't want me to. If they had anything parked in there, they will tow it.
All right. So the best advice to you, Mike, is to go visit a real estate attorney to develop a plan to protect your property if possible, or negotiate with the other side to do something that makes sense maybe for the both of you. I think you are probably not in the driver's seat on this issue, but you really need somebody. You need an advocate to fight a little bit for you and see if they can make something happen.
Okay, I just wanted to see what's going on there. Like I said, they put the fence there, and I want to see if they have any legal grounds to put them for us.
They did put the fence there?
Right.
I see. Well, you need to see an attorney right away.
Right.
You might be able to get an order to take it down or whatever, but if they own the property and your driveway is on their property and you knew that going into the deal, you're just going to have to deal with it now.
I mean, yes, if you can't do anything about it, I know if it was. So
I'm not going to tell you can't do anything about it, so I think you just need to go see an attorney to have them look at the whole picture and see if they can't work something out for you.
Okay, is there one you can recommend, any real estate attorneys or?
You can call my office and ask for Jim.
Okay.
And so it's 727-586-33. 586-3306. He's extension 116.
Extension 116. Oh, okay. Thank you. Yes.
All right. I wish you well, Mike.
All right. Thank you.
All right. You too. If you'd like to call Ask an Attorney today, all about Florida law, it's a live show. You're listening to a live show, and you can, unless you're listening on Sunday night, they replay the show on Sunday night from 5 to 6. Other than that, it's live, and you can give us a call at 877-943-9673. Phone lines are open, 877-943-9673. Phone lines are open. Let's go to Mark in Tampa.
Good morning, Joe. How are you?
I'm doing great, and you?
Very good. My elderly father recently redid his will, and the attorney told him that, I don't know if there's particular things about this super-duper will, but the attorney told him that this will would avoid probate.
Well, no, there's a I call a living trust a fancy will.
Exactly, and this is not a trust. This is a will, but the attorney told him that it wouldn't have to go through probate. That's not accurate, is it?
If you die with an asset just in your name, I mean, it's not jointly held with anyone, it doesn't have a beneficiary, so you die, the asset's in a deceased person's name, it would have to go through probate. I've never heard of a super will that could avoid probate.
Well, I'm throwing that adjective on it, and he was adamant. So if his home has someone else on the deed, then it's a possibility that when...
Yeah, any asset jointly held with right of survivorship doesn't go through probate. It goes to the survivor.
And listening to you over the years, you have to be very careful on how that is on the deed.
He probably needs to ask the attorney, well, I have this asset, I have this bank account, I have this CD, it's just in my name, it's not jointly held.
Right.
It doesn't have a beneficiary on it. How is my beneficiary going to get this asset except through the probate court? And just nail down a very narrow question and see what the answer comes up to be.
Now, he's recently redone this will. His stepdaughter, within weeks of him redoing the will, took him over to his general practitioner, and they did a dementia test on him.
Mm-hmm.
And they said he has mild cognitive, whatever. Now, the stepdaughter has power of attorney. I know she's on the checking accounts and whatnot, but I don't know if she's on the house. Doesn't all that all just sets up all kinds of problems and potential problems, doesn't it? Because if her name is on all of his assets, then if she were to be sued, all of those assets are up for grabs, right?
Yeah, if she's a co-owner of the assets now and she gets sued, those assets are in jeopardy. That's true.
And if she proceeds, this is maybe conspiratorial, but if she proceeds to push kind of on this dementia business, at some point, with her having the power of attorney, she could do whatever she wanted to with all of these assets, right?
Well, you can't legally use a power of attorney to benefit yourself.
Oh, okay.
Also, mild dementia is not a disqualification of being able to make a valid will either.
Right. Okay.
All right, so it depends. I interview people all the time. Some of them might have mild dementia, but if they can focus, we can get good eye contact and they can focus on me and they can answer my questions and they know pretty much the nature and size of their estate. They know who their beneficiaries are and they know what they want to do. Right. With mild dementia, it's possible for a person to do a will or trust.
And to avoid all these problems, just create a trust, Dad, and put everything in the trust.
Yeah.
And it's not expensive, and it avoids all these potential problems.
Yep.
And we can't convince him of that.
Yeah, I think that'd be better advice.
Absolutely.
Hey, you can have him listen to this show Sunday night between 5 and 6, around 5:15.
That's not a bad idea. I'd like to do that.
Yeah, get him to listen to it because they redo the show.
Very good.
All right.
Thank you so much.
Thank you.
Bye.
You're listening to Ask an Attorney, all about Florida law. I'm Attorney Joe Pippen, practicing attorney. The law office is open. It's open right now at 8:17 on Saturday morning. If you have a question and I can help you, all you have to do is to call the toll-free number, 877-943-9673. And since we're talking about what I call undue influence, this happens in my office every week. Person comes in, brings their parent. They try to start talking for the parent, telling me what the parent wants to do. Lots of times they're going to be favored in the distribution over the rest of the children. And I almost immediately get to the point where I can't help you today. I don't do documents where someone is influencing or trying to influence someone and they are favored in the document, because all you're asking for is a lawsuit at the end of the day. And the lawsuit, it would be an undue influence argument. The two main reasons wills and trusts get contested are undue influence or incompetence. Now, undue influence is the higher percentage of times where somebody challenges the will or trust and they win. So what do you basically have to prove as undue influence? Well, you ask 50 questions to make the person that influenced the parent, look bad. Did you bring them to the office? Were you sitting in the office with the attorney? Did you discuss this on the way to the office? That you would, get half of the estate and the other 3 siblings would split half? Or you wind up with everything, and did you take him to the bank to put your name on his account? So undue influence is a big issue. So immediately when that comes up, I almost say, look, I can't help you today. You're going to have to, if you really want to do this, you're going to have to come back on your own, arrange your own transportation, get here by yourself. You can't have an interested party sitting here in the room or even have brought you here and hope this is going to work. You'd have no peace of mind this is going to work, and I'm sorry I'm the one to have to tell you that, but this is the way you can make it work. Undue influence, it's not a good thing. Let's go to Jenny in St. Petersburg. Hey, Jenny.
Hello.
Hi.
Hi.
Hi. What can we do for you today?
Okay, I just really woke up and heard your show, but I do have a question, and I hope that I'm in the right ballpark. I don't have any idea. But anyways, I got kicked out of my house, kind of, a mobile home park. Is that relevant? Okay. And the reason I got kicked out is because...
You were legally evicted?
No. That's what I'm saying. I got kicked out, kind of by the cop.
A policeman came to remove you from the property?
No, I called the police because somebody was going in my place. I was having moving sales, but I was still in the place. And a neighbor called me and said people were coming in and taking something, another neighbor, and somebody else was coming in and removing things. So I called the cops to meet me there to get to stop it. And when I got there, the cops said, no, this place was sold from under you by somebody else, and I knew it was a scam because it was a neighbor who is up to no good usually. And so he told me that he bought the place and there was a homeless guy in there. And so the cops told me I couldn't go in and get my stuff. They said, you can get your big ticket items. This happened to be Thanksgiving Day. And I said, no, I can't because I've got a turkey in the oven. I got to go. So then anyways, I left. But when I came back about 2 weeks later to come get my stuff, that turned into a burglary and a burglary case because I went in the house. Although he opened the door, I went in the house. Anyways, now it went to court, and they took the trailer from me. The trailer park did. But I'm saying if I have a leg to stand on to get back in that trailer park, because now my my public defender is telling me that she called him and told him that I did not bring the homeless in. That's how the story went, how I told you. Mm-hmm. And now they kicked the homeless out yesterday. And how can I get my trailer back? Do you think I have a leg to stand on with an attorney?
Well, I don't know if I know all the facts of the case. So you don't own the land underneath your trailer.
No,
you just have a
and
title.
I don't own the trailer. I was staying there with a friend's trailer. He went to the Philippines. He doesn't even know any of this happened.
Okay. So you never owned the trailer either?
No. But still, shouldn't I have a place to live? I'm disabled and over and 63.
Well, sure, you should have a place to live. But if you never owned the trailer, then you don't have a right to get the trailer back.
And what about the police had a right to tell me I can't go in there anymore?
Well, if you never owned it, regardless of who the homeless person living there didn't own it either, but you didn't own it, and somehow or another the property seems to be transferred to someone else who did own it, and then since you entered the property...
It never was transferred. It never was sold. That was a scam. That was just
Yeah,
again, the trailer's sitting there now and belongs to the trailer park, and they get to rent it out to whoever. And I don't have a place to live.
Listen, I have a little ethics problem, I'm going to call it, by even talking to you at this point, because you're represented by an attorney, the public defender, who knows a lot more about this case than I do. So I think you let your attorney represent you and advise you, and I don't think you can call someone on the radio for a few minutes and hope to get a different answer. So,
Okay. Well,
thank you. I'm sorry. If you're represented, I can't help you. And since you don't own the property, I don't understand how you could proceed. But your attorney has enough facts to be able to fully advise you if you can or can't.
Okay.
Thank you. All right. Thank you. Let's go to John in Sarasota. Hey, John.
Hello.
Yeah.
Hey, good morning. Calling from Sarasota. I got an easy question for you.
All right.
Both my wife and I have a living trust. What's the appropriate way to go ahead?
Do you have a joint trust or individual trust?
Oh, no, individual.
Okay. So
and I wanted to know how to name a joint checking account.
Okay, so since you have individual trust, you could create a joint trust for your jointly held property.
Okay.
But you wouldn't put an individual. You wouldn't put a joint trust to an individual trust normally. There's no good way to do that. However, if you own the account jointly and one of you died, the survivor could put it in their trust.
Oh, okay.
Or if you have if you have enough other, do you own a home jointly or separately?
Jointly.
You own the home jointly? Okay, so you can create a joint trust for the home and a checking account, and still keep your other assets separate if you want to. What was the reason you created separate trust? It was a second marriage where you had separate assets going into the marriage?
Well, no, we both did living trust individually.
And how long ago?
Oh, we just had it reviewed here last year.
When was it created, though? How many years?
2003.
Okay, so a common reason for people who did individual trust in 2003 would be that the tax exemption was much lower. I don't have it.
That's accurate, right?
Okay, so say it was $1 million. I have to backtrack and look at a little chart to see exactly what it was. But let's say it was $600,000 or $1 million, and you had more than that, so you created two trusts to get two tax exemptions.
Right.
Well, now you can look at the whole thing through different eyes, because now the tax exemption's $11.4 million each. So you could do one joint trust, possibly, if you're under that number. One joint trust and own everything. Do you want the survivor of you to own everything upon the first death?
That's true. Correct.
Yeah, so now you can just do a joint trust and combine everything into one trust instead of having two.
Oh, okay. Well, I guess I'll have to go ahead and do that.
Something to think about.
Okay, well, thank you very much.
Thank you. And the reason why a person would do that would be because if you want the survivor to own everything, there's no real reason to have a separate trust, because those separate trusts a long time ago, how they worked is if one died, the surviving spouse didn't get everything outright. They got income only and a 5% invasion right on the principal. So there was a great big restriction on what they could get from the deceased person's trust. And now because the tax exemption is up to $11.4 million each, a lot of my clients did the old individual trust because their tax exemption was so much smaller, now have come back in to do one joint trust. And I think that's a common plan for like a first or long-term marriage where they want the survivor to own everything because there are restrictions involved in the separate trust. Hey, if you have a legal question, the law office is open at 877-943-9673. That's 877-943-9673. Law office is open. Let's go to Rose in Tampa.
Good morning, Joe.
Hey,
my question is, when you are on workman's comp disability and a gift is given to you, let's say, if a parent dies and she leaves, her assets to to that individual, can the government come and take that away from that person?
No, that's a protected amount of money under the Florida Statute 222. A government benefit like that cannot not be taken away from as an asset protection thing. Now, it depends on who it is, though. If it's the IRS or somebody like that, seems like they can pierce through anything to get to assets.
So the IRS can do it, but no one else can do it?
No individual creditor could do it.
No individual creditor, but IRS can do it?
They might be, but I doubt that they would, actually. I've never heard of the IRS coming in and taking anybody's workman's comp, even though they might have the right to.
So they have the right, but you haven't heard. Okay. My other question is this also. If you live in a house and you're part owner of a house, and you choose to leave the house for about a year, and then the person that is staying with the house wants to refinance the house, what obligation does the person that left the house has?
Well, the person who left the house owned the house?
They part owner of the house.
Okay, so it's like a 50-50 ownership?
Right.
I think that you can't refinance a house unless you both approve. I don't think a mortgage company or lending company of any type is going to let one who owns a house jointly just that. They're going to need both signatures to refinance.
Right, and let's say they both agree in refinancing the house because the person wants to take the name off their house.
Well, taking their name off the house is a different issue. A person can do a quitclaim deed to take their name off the house, but that doesn't release them from the mortgage obligation. So if there was a foreclosure, they would still, even if you did find some way to do a deed and get your name off of the ownership of the property, that doesn't release you from the mortgage obligation. And even if you both agreed to refinance, there'd be no reason for the person who didn't want to own the property to be part of the refinancing and obligate themselves for the payment of the debt. So if one of you wanted to get out of the deal and the other one was fine with that, just the individual who wants to own the property and stay there should be the one to do all of the financing, and that should all be approved before the other person signs off on a deed giving them the property or selling them their interest in the property.
So in other words, let's say the male wants to keep the house and refinance the house, and the female wants to get out of the house and get the name off the house.
So the female who wants to get out of the house should, the one who wants to stay in the house, the male, should see if he can refinance on his own strength. And then if so, and he's approved, then the female could sign off on the transaction so she would no longer be an owner or be obligated on the mortgage.
Right. So is there any part on the females that she's responsible for? Not if
he can totally refinance it himself. So the female would sign off the deed, when at the closing, when he could prove that he could refinance himself and he's been approved.
Okay, so the fact that the female hasn't been there for a whole year, is she responsible?
No, being absent doesn't mean anything as far as your question goes.
Okay, and any repairs in the house that has been done, does the female have any responsibility to that when he refinances the house?
Well, he has knowledge of the repairs, so if he gets refinanced and can handle it himself, and you're okay with signing off, no, you wouldn't be obligated at that point.
Okay.
You would basically sell it to him as an as-is property, and he would agree to refinance it and see if he can be approved.
And then all the female has to do is just sign off, and she's not responsible for anything.
Not if, yeah, correct. If he can get refinancing on his own, yes.
Okay.
All right, Rose. Sounds like you would need representation, though, just to give you a little peace of mind how this, if that's what you want to do.
Okay. You also had a cell number. Am I able to get that?
If you want to send me a text or something like that, it's 727.
Okay.
667.
667.
3967.
3967. Okay. Thank you, Joe.
All right.
Very
Thank
helpful.
you. Thank you.
Very much. Bye-bye.
Hey, if you'd like to call the show today, you have about 20 minutes left, and the toll-free number is 877-943-9673. And just to mention, we're broadcasting live today on WeBeam TV. You can watch the show if you want, WeBeamTV.com. Also, on my Facebook page, we're streaming the show live. That's Ask an Attorney page. And also, we have several of the shows on a little YouTube channel we've created. Previous shows from WeBeam TV, and that been Facebook Live, we've created a little YouTube channel, Ask an Attorney. The name is Joseph Pippen, so if you want to check that out, feel free. And glad to, you might be able to watch me answer your question, as I do many other questions on WeBeamTV.com or Facebook Ask an Attorney, all about Florida law. If you would like to call the show, we have less than 20 minutes to go, so give us a call, 877-943-9673. 877-943-9673. I was talking early in the show that I love to do speaking engagements. I've got this coming Thursday morning, I'm doing my Trial of Jesus presentation to a large men's group in the Sun City Center area. We're really looking forward to that. And we'll probably do the Trial of Jesus show coming up in Easter this year. And it's a show where we go through the laws back then, the 17 errors that the court made with Jesus, going before the Jewish courts and the Roman courts, comparing the laws back then versus the laws today. So looking forward to that. If you need a speaker for your group, all you have to do is to call our toll-free office number, 1-800-226-3529. That's 1-800-226-3529. And let's go to Basco in Savannah.
Yes, it's Bosco.
Bosco, B-O. Okay.
Yes, B-O. Awaiting this parade in Savannah. Ought to be a lot of fun. My question is, a friend of mine that's approaching 65, who's on disability, was telling me that he can work when he's on disability.
There's a wage. There's a wage limit that you have to come under. I don't know. I don't remember exactly what it is because I don't really practice in the area. But you can work, and you can make up to a certain amount of dollars, and still get your disability payments.
That just doesn't.
It's a fairly small amount of money, though. I don't know. I can't remember. Maybe somebody can call and tell me what it is. It was $5,400 or $7,400, somewhere in there, I think, where a person can earn some money and still keep their government benefit.
That's wild. That's wild. Is that something Obama's?
No, I think there's always been an age of where you could make a little bit of money
and still be disabled. That's incredible.
Well, I mean, there are a lot of a disabled person that's like in the wheelchair can answer phones. There are certain things that people can do. You know, organizations like Goodwill train people, disabled people, to work. You know, you go into a Publix grocery store, you see some disabled people that can handle a job and function. So, I don't think it's that unusual.
Well, I can see that side of it. You know, my big question now, since they're thinking about dishing money out to people that, are not disabled, but they feel that they need to have a minimum income. And my thought is a minimum income should be go get a job. And that will provide you with a minimum income, and then work your way up, train your way up. Yeah.
All right. Well, thank you for calling. Thanks
for your time.
All right, thank you. Let's go to Monica calling from Sarasota. Hey, Monica.
Hi. Several questions about a living trust. I'm at the point of, because I'm a single female, no children, never been married, I'm at the point of deciding whether I just go with a will and let the person I choose as personal representative, who would also I would list as a beneficiary or inheritor of the house. They would just go through a probate, meaning the I think it's summary administration, because there's a homestead on the house. And I know that most often, I've listened to you before, you mostly recommend the living trust. I guess I have a hard time giving control over to somebody. And my question would be, if I do the living trust, I think bank accounts and money, et cetera, goes by percentages to individuals. I also have, besides the personal representative who I would want to become an inheritor, I would want 2 persons in Canada. And I was thinking the living trust perhaps would be the best way to go if indeed it's true that in a living trust you can name somebody outside the country, because Canadians would be considered foreign. In other words, from what I've done reading, that regular will, you have, as a person in my situation who has no relatives, I have to name somebody who is a Florida resident to become personal representative. Is that true?
The personal representative can be a Florida resident or a blood relative.
Right, and I don't have the blood relative. That's the problem.
All right, first of all, I think a trust would be people without children or family or husband, spouse with no children. The big benefit to a living trust for those people is the successor trustee. And by the way, you don't lose control because you're the grantor, you're the trustee. There's no...
Well, I agree, except that the money being in CDs, what I do is I have various banks that I'm associating with. Mm-hmm. And when a CD expires, I have that choice of putting the new beneficiaries on in a certain way. In other words, the amount that they get. I'm the one kind of controlling that, whereas once you have that living trust, you've got that percentage, and it's not going to be varying too much unless you maybe pay more money to alter it.
All right, listen to me just for a second. Let me finish my thought where I was going with why a trust would be beneficial to you. So people without a spouse or children, the trust is most beneficial because if you become incapacitated before death, for a period of time, the successor trustee that you choose, who only has power when you die or become incapacitated, now can come in and manage the trust for your benefit and a lifestyle to your custom, and avoid the probate and the guardianship aspect of things. So the big benefit to you would be you'd have someone to manage things for your benefit if you became incapacitated, and a lot of people become incapacitated somewhat for a year or two or more before they die. So the big benefit to people without a family member, a close family member to leave it to, is it avoids guardianship, and then at time of death still avoids probate.
Okay, that's fine. The next question is, can the Canadian be named the secondary trustee? In other words, like I have a person from Florida who is a good friend who I trust implicitly, who I don't mind naming as guardian, and I think that she would do fine with power of attorney should I be incapacitated. I trust her to do that. The secondary person I would trust is the person in Canada. Can a Canadian be named in a living trust?
Yes, but it's usually not advisable because the trustee might be subject to the tax treaty rules in that country. So generally you want to keep your U.S. successor trustee to be a U.S. citizen, who can live anywhere. You don't have the same rules about blood relative or resident of Florida. They could be anybody in the United States, but I would not name a Canadian as a successor trustee on a trust.
Wow.
Now, an attorney or a CPA or a financial organization with trust departments and things like that, those would be the 3 most common choices for a backup to your friend to serve just in case something happened to your friend.
Right. That's the whole thing. The way trusts work, which I don't know, but is it true that with a living trust pertaining to the monetary assets being in a bank, the individual successor can just go to the bank and then they change the money over to the trust and then they divide out by percentages?
Well, no, you change the money over to the trust while you're living.
No, I don't mean that. I mean, I've already died and all the assets are named in a trust.
Right.
Like everything's been over. I have the trust already. And when they take over after I die and it's in the trust name,
The successor trustee then just takes your death certificate into the bank, and they become the trustee. Then they follow the instructions in the trust, basically.
Okay, but how about pertaining to the house? How does she obtain the house?
Well, if I were doing this for you, we would do a quitclaim deed, putting your house into the trust now. So usually clients don't have those recorded till they die. Then the successor trustee would record that deed, and then they would follow the instructions in the trust about doing a new deed out of the trust to whoever the beneficiary of the house was then.
Okay, so the quitclaim deed is the thing that gets done, but that just gets set aside until I pass away, and she then goes to a lawyer to get the quitclaim deed filed?
Yeah, it's recorded at the time of your death, yes.
Oh, okay. I never knew any of that. It's kind of hard to follow as much as I try to read the details on the Internet.
Yeah. Well, you can't be just sitting down with an attorney, having an attorney that does this all the time explain it to you, so...
Well, no, I
yeah.
agree.
And we have an office in Lakewood Ranch, by the way, if you choose to use our services.
Oh, I think that's a great idea. I would appreciate that very much. I mean, if they're like you are and answer questions, where one can understand it.
Yeah, they very much are. So.
Okay. All right. Well, I appreciate the answers very much.
All right. Well, thank you, and have a great day.
Thank you. You too. Bye-bye.
You're listening to Ask an Attorney, all about Florida law. We're down inside 10 minutes left to the show. If you'd like to ask a legal question, we have some open lines right now. 877-943-9673. That's 877-943-9673. Phone lines are open. If you would like our free estate planning poster sheet, we'd love to mail that to you. It's a big, large, double-sided sheet. You can look at it on our website, www.attypip.com. Better yet, we'd love to mail it to you so you can have it. It's a big, like I said, a big, large, double-sided poster sheet, all about estate planning, has all of our contact information offices on one side and 5 articles about your options in estate planning, living trust, wills, probate, and all that, cost of probate on the other side. You can get it one of 3 ways. You can call our toll-free office number, 1-800-226-3529. That's 1-800-226-3529. You can email me at Joe, J-O-E, at attypip.com, or you can text me at your name and address at 727-667-3967. Let's go to Todd in Tampa.
Joe.
Yes.
This is Todd in Tampa. Just want to chime in. Called you a couple of times. I think you do a great job and a great service for people. God bless you. And Joe, 2 things. One is, when people get in trouble and they have to hire a lawyer, I used Bush Ross before. Paul Huey was the greatest lawyer because he was a righteous dude, but now he's a judge. But, when people hire a lawyer, people don't understand and that, the lawyer, he may, Bush Ross, they could wait 90 days for their payment. But some of these lawyers, they want their money now or they don't show up to court and the judge looks at them like they're, a criminal, the defendant, and it's a disgrace. I know a girl who got punched in the chest by her boyfriend. Okay, and then the boyfriend told her to go get some spice down the street, or I'm going to punch you. You sent her to the hospital, but the judge never hears the case because it's always, supposed to be done with the prosecution, and all the prosecution cares about is a prosecution. So, and it's Judge Ward. And my point is that. You get a lawyer, you pay a lawyer, you got, a $3,500 fee you got to pay the lawyer. If you don't pay the lawyer, he doesn't show up or he goes to court. I had the attorney go to court and say that the defendant didn't pay me. Well, my God, $3,500 for in 30 days is a big hit for an average individual.
Hey, Todd.
Todd.
I really want to thank you for calling, but I need to move to my next call. But thanks a lot. Bye-bye. Let's go to Skip in Jacksonville.
Yes, sir. Good morning.
Good morning.
Quick question. I got in late hearing about probate earlier.
Yes.
Could you just give a short dissertation about probate, what it is, how do you start it, can you do it yourself, why do you do it?
Well, probate is it's really simple. Probate is the process of getting assets out of a deceased person's name. When you have a will, you're probably going to have assets in a deceased person's name. If you have a living trust, the trust is still living when you die, and the assets in it don't go through probate. So if your homestead is just in a deceased person's name, you do a petition to determine homestead to the probate court. And then if you have a will, you follow the instructions in the will. If you don't have a will, you still have to go through probate, and then it goes to your heirs under a family tree type of statute. The minimum probate fee we charge on cases, we really try to help people avoid probate, but the minimum fee that we charge if we have to take an estate through probate is $2,500. It's 3% of the value of the probate estate, or $2,500, whichever is higher is the cost, and there's about $600 or $700 in court fees and so forth. In court, bonding, advertising, there's a fee for that. So people that want to avoid that whole process, and I've had fairly small estates who said, look, I don't want to pay $600, $700 in fees and costs, and I don't want to pay an attorney $2,500. Let's do a living trust. The fee for a living trust, we have flat fees for that, is $695. You could avoid that. And $795 for a married couple. And if you were a married couple that came in to do 2 wills, 2 power of attorneys, health care surrogates, and living wills, the fee for all of that would be $620, but you'd still have some probate, so you can spend just a little bit more and do a trust to avoid it.
Okay, in a will, if all the assets are accounted for and distributed in the will for beneficiaries, do you still have to probate?
Yeah, well, if you have to probate, if you die with an asset just in your name, it doesn't come out of a deceased person's name with it unless you go through probate.
Even though there's a beneficiary described in the will?
A beneficiary described in the will still leaves the asset in the deceased person's name. So, yes.
So the only way he gets it out of the will upon death is through probate?
Yes, sir.
So living will's the way to go.
Living trust. That's what most of my clients do.
Yeah, okay.
All right.
All right. Thank you very much.
Thank you. And by the way, for the listeners, we do have offices in Jacksonville. I go there. I'll be there this coming weekend, starting on Thursday, Friday, and through the weekend. We broadcast from Jacksonville every other week. We broadcast from Tampa every other week as well. So if you'd like to call our office, we have a toll-free number, 1-800-226-3529. So either to make an appointment or to request the poster sheet, 1-800-226-3529. If you'd like to email me your name and number, it's Joe, J-O-E, at ATTYPIP.com. Let's go to Chris in Tampa.
Good day, counselor.
Hello, Chris. What can we do for you? We have less than 2 minutes, so we've got to make this fairly quick.
Okay. Can I ask you just a really quick side question?
Sure.
Do Catherine and Jim still do another show?
No.
Oh.
No, Catherine's mother passed away, so she took a sabbatical. I'm not sure when her return date will be at this point. So.
Is she coming back? Is she going to be doing that?
I'm not sure. I keep inviting her to come on this show once in a while, but she's just not ready yet. So.
Okay. My question for you was, I think it's simple. I hope you can give me a positive answer. My neighbor's tree has grown through across the property line and into my pool cage, punching through a number of my screens on the pool cage. I was just wondering if I have any leg to stand on, if to ask him to,
Well, you can ask him, but you have the right to trim the tree up your property line.
But I mean, are they responsible for any of that if I took them to court?
No, probably because your homeowner's policy will cover it.
I don't have any homeowners.
Okay. No, your right is to trim the tree up the property line, basically.
So I can't sue them in any way whatsoever?
You could sue them, but I doubt you'd be successful.
Really? Okay. That's what I was wondering.
All right, Chris.
Hey, thanks, counselor.
Thank you. All right, thank you for listening to Ask an Attorney all about Florida law. If you'd like to contact our office, it's 1-800-226-3529. 1-800-226-3529. Go to extension 200. And if you'd like to email me, it's Joe, J-O-E, at ATTYPIP.com. You have a great weekend. So long.
right, Kevin McCullough. Have you ever